Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. I'm going to get to talk about a state that I've rarely had an opportunity to talk about. I've got to spend some time there the last couple of years. I think the state is absolutely fantastic. But every time I've been out there, everyone's been telling me about this crazy gun law that they had out there. And I do use the word had because, well, it's been struck down. But it appears that the state is going to appeal this to a higher court because they want it back. And when you see what this law does, and when you see when it was actually created, you're going to ask yourself, why are they doing this? So today, let's spend a few minutes and let's talk about the craziest gun case in America right now is in Tennessee. That's right, America. We're going to be talking about a crazy case going on in the state of Tennessee. The matter that we're actually going to be talking about today is Hughes versus Lee. Now, it comes out of the Chancery Court for the state of Tennessee, 28th Judicial District, Gibson County, which never in a million years did I think that I would be citing to a published opinion out of that particular court. Now, this is a successful challenge to Tennessee Annotated Code, Section 39-17-1307A, better known as the Going Armed Law. And we're going to talk about that one predominantly. It's also a challenge to Section 39-17-1311A, which is a prohibition or essentially turned parks into gun-free zones. Now, I tried to do some research about Tennessee's going armed laws and was rather unsuccessful until I happened to find this law review article entitled Pocket Pistols, Spanish Stilettos, and Arkansas Toothpicks, A Post-Bruin History of Weapons Regulations in Tennessee by Emily Ann Crawford, mentored by Jacqueline Dixon, which explained that in 1801, the very first version of the going armed laws was passed by the Tennessee state legislature using the Statute of Northampton as legal authority. Away we go. This statute has essentially been in place for well over 200 years. The current version, though, of the statute reads, a person commits an offense who carries with intent to go armed a firearm or a club. Now, I went through all 44 pages of this opinion, 24 of which are not necessary unless you really want to geek out on Tennessee Second Amendment and gun law. What I did find, though, in looking at the procedural history is that the state of Tennessee, and this Attorney General in particular, has been fighting like holy hell to preserve this law. Let us also remember in 2012, there was House Bill 3499, which would have clarified this law and made all concealed carry license holders exempt. That went nowhere. And then let us also remember that in 2021, Tennessee became a constitutional carry state, yet this statute remained on the books. Okay, after going through a brutal 24-page journey about, well, even though this was filed under the Tennessee State Constitution, the Second Amendment really applies, the court finally gets to the punchline when they rule the going armed statute, by its use of the phrase the intent to go armed, far from criminalizing an intent to terrorize the people, instead criminalizes an intent to carry for the purpose of being armed and ready for offensive or defensive actions in a case of conflict with another person. In other words, the going armed statute criminalizes the entire right to bear arms portion of the Second Amendment. Inherently, there can be no tradition of such a regulation in our history, nor can there be any legitimate sweep to such a statute. And for that reason, the court has found, accordingly, this court holds that the going armed statute violates the Second Amendment to the United States Constitution and therefore also violates Article 1, Section 26 of the Tennessee Constitution. With respect to the going armed statute, plaintiff's motion for summary judgment is hereby granted, and defendant's motion for summary judgment is hereby denied. Then when it comes to making parks gun-free zones or sensitive places, after going through another 10-page, very long, brutal journey comparing parks to schools, ultimately the court has ruled. Accordingly, we conclude that the park statute violates the Second Amendment to the United States Constitution and therefore also violates Article 1, Section 26 of the Tennessee Constitution. Plaintiff's motion for summary judgment is hereby granted with respect to the park statute, and defendant's motion for summary judgment is consequently denied. Okay, now one would think, considering the political breakdown of the state of Tennessee right now, we're currently in the Senate, the Republicans hold a 27-6 advantage, and in the House they own a 75-24 advantage. And considering that your Attorney General, Jonathan Skrmetti, is of course a Republican, they would just let this lie, right? No, quite the opposite. You see, actually this goes back to a lesson that we did with this video right here about New Jersey, which is, with friends like this, who needs enemies? Because the Attorney General now believes that the going armed statute, since it's been struck down, suddenly opens up an entire floodgate of otherwise illegal gun activity, oftentimes involving either underage people or those that are intoxicated. Now, I've had an opportunity to look at the statutes. I'm not really sure what the Attorney General is talking about, but it would seem when we go back to the board here that anything that needed to be clarified or tightened up could certainly be done so at the very next legislative session, and probably in very short order. So despite the fact that a horrifically unconstitutional and ancient gun law has been stripped from the books in the state of Tennessee, it appears that the Tennessee Attorney General, Jonathan Skrmetti, is hell-bent on fighting to uphold this law and will choose to appeal this case, thus making this, right now, the craziest gun case currently in America. Okay, the case once again is Hughes versus Lee. We're gonna link it up down below so that you can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Why in the year 2024 should anybody even think about having self-defense protection? Because, 25 years ago, we would have never had this conversation. So what's different today?
Bill, we really saw a need a number of years ago when the volatility and divisiveness of our country started to change drastically. And we, by the way, are gun people protecting gun people. We come from a significant gun background.
Right to bear, that's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.